Hi, I'm Dan. I am on the beautiful island of Madeira, which is part of Portugal, on vacation at the moment. And a little bit of downtime we've had in a little bit of downtime that we've had, I was perusing Facebook. I haven't had Facebook in a long time, but scrolling through like one does. And one of the things I've seen is actually several videos of people getting detained by ICE back in the United States. And I saw one video on Facebook where this U.S. citizen was detained and he was able to film it. And I was kind of disturbed by some of the comments that go with the video, basically saying, what's the problem? He showed a citizen, he was released after, it was a few hours, no harm, no foul, basically. And I thought to myself, well, first of all, he was detained and he was on his way to work, so he missed work, so there's the harm in itself. But it seemed to me to be a clear violation of the Fourth Amendment. So I started thinking, why is it people don't understand the Fourth Amendment and where it came from? So I decided to do a little digging myself and find out, what is the history of the Fourth Amendment? Why was it a core part of the U.S. Constitution? So I looked it up, did some reading this morning while my wife was sleeping from jet lag, and I came across a couple interesting historical facts. One is, if you go back to before the Revolutionary War, actually England, 1763 approximately, there was a gentleman by the name of John Wilkes. He was publishing pamphlets that were critical of the British government and specifically of the king himself. And of course the king was not happy about this. And they used this process called a writ of assistance, which was basically a document that was created by a government official, and anybody that carried the document could, at their discretion, search people's property, seize papers, seize people for that matter, all under the guise of promoting this general idea. In the case of John Wilkes, it was this idea that he was somehow subversive to the king. Well, in a court ruling in England prior to the founding of the United States, in what's called a Wilkes v. Woods, the court ruled that the seizure of his papers, of his possessions, was illegal. And let me just quote from you the passage from the court ruling that was particularly struck me. The court declared that such broad warrants, for example, was, quote, a discretionary power given to messengers to search where their suspicions may chance to fall. If such power is truly invested in, I'll paraphrase, in the head of the state, it may certainly affect the person and property of every man in this kingdom, and here's the operative part, and is totally subversive to the liberty of the subject. Now, it seems like even under the king, even before we had our Constitution, they understood that such actions, such broad powers to search or seize, violated people's basic and fundamental liberties. There's a maxim that comes from English common law, which says a man's home is his castle. And that's basically what they applied, was a man should be able, a woman, a person, should be able to do what they like, as long as it's not harming somebody else, in their home, and be able to speak freely, including making pamphlets and writing and so forth. There was another case where an associate of Wilkes, last name was Entick, I believe, took the crown to court for, he was also had his papers, his house broken into, his papers seized, and so forth. And the court ruled in his favor as well that it was a fundamental violation of his liberty. So again, the British knew even before our own Constitution that such broad powers were a violation of fundamental liberties that we expect to have. However, the British continued to use the writ of assistance means of obtaining evidence and searching people and property in the colonies even after these rulings, until they realized that they were starting to lose the loyalty and the trust of the colonists, and they really needed their loyalty to the king to be able to rule the colonies effectively. So they gave up on this writ of assistance, because it was really, if any government official essentially can break into your home for any reason, it's going to be hard to trust the government to do the right thing. So they dropped the use of the writ of assistance until 1773. You've heard of the Boston Tea Party. That was a protest against taxation without representation. That's a whole different subject. But again, the Crown was not happy about this, and they reimposed the writ of assistance as a means of punishing the colonists for their subversive behavior. In this case, they wrote them to gather evidence about potential smuggling and people bringing in goods to the colonies without first being taxed by the king. So they used it as an excuse, again, to break into people's homes, to seize people and property without having what the Crown would call reasonable suspicion that they were actually involved in this activity or committed some crime. In fact, it was kind of interesting how the writ of allowance worked. It could be written by a government official, and it lasted the lifetime of that official plus 6 months. So anybody holding this paper could essentially say, I'm confiscating your papers, or I'm breaking into your house, or I'm arresting you based upon this broad, amorphous authority of the writ. And there was really nothing that people could do about it at the time. Well, it's that background of the writ of assistance being used as a weapon against the people to punish them and intimidate them that James Madison introduced the language of the Fourth Amendment. And the Fourth Amendment gives a person security in their home and their person, and requires the government to show via a signed warrant that there's reasonable suspicion of the specifics. They can, if the government says, well, we think they have this particular document or this particular good that hasn't been taxed, here's the evidence for it, then the judge can sign it, and they can go in and search for and seize that particular item. And they saw that as, the founders saw the Fourth Amendment as really a bulwark against using the power of the state to intimidate and punish their own citizens. So, knowing why we have the Fourth Amendment to begin with, you can see that disappearing people off the streets, as we're seeing happen today, or taking people that are just on their way to work for no other reason than their skin is brown, and some ICE official has some inkling that maybe they might not be here legally, is really a direct violation. And by the way, say nothing of 2022, there was a court ruling, an agreement between plaintiffs that were illegally detained and ICE that they wouldn't do this anymore. So the current spate of abductions is not only patently against the Fourth Amendment, it's also breaks the agreement that ICE made with plaintiffs from the 2022 agreement. And just the other day, a district court judge in the Northern District of Illinois ruled that what ICE was doing was unconstitutional and stayed them from doing that for the next several months at least, while more evidence is gathered. So you can see over 260 years ago, the British recognized that such broad powers were anathema to a person's individual liberty, their basic fundamental right to liberty. We codified it in the Fourth Amendment of the Constitution, and now you can see what the Trump administration is doing is violating those core principles by arresting people for no other reason than the color of their skin or where they happen to be working. It's really despicable. And by the way, the other things that the British did, in addition to the writ of assistance, is they deployed the military. For example, they closed Boston Harbor. There was military rule in certain areas. So you can see some very striking parallels to what the British Crown did to oppress American colonists before we were a country, and what the Trump administration is doing now. It's wrong. It's obviously wrong, and we should, as a country, know better. So we're asking, oh, what's the harm? He was released. He was able to show that he was a citizen, no harm, no foul. Well, James Madison knew. The British government, or at least the British courts, knew that it was a problem, and they recognized it over 260 years ago. So I would think that Americans should be able to recognize it today. You know, we actually fought a war over just this type of abuse of power. I hope we don't have to do that again.